called People versus Jackson. And that site is 15 Calat Court, 1197. In this case, the court completely precluded defense witnesses, a defense witness. Because here, I'm going to quote from the case. Here, because the testimony was allegedly exculpatory, the trial court refused to believe defense counsel did not seriously consider calling the witness until moments before he did. Even if withholding the identity of the witness was not willful, lesser sanctions would not have been adequate. Immediate disclosure or contempt of counsel would have been insufficient because the people would not have had a meaningful opportunity to rebut or impeach the statement. Similarly, a continuance would have been inadequate because the declarant's whereabouts were unknown, and thus her unavailability precluded the people from cross-examining her. The people would have been unduly prejudiced by admitting the testimony without an opportunity for cross-examination, and the integrity of the adversary process would have been compromised, as parties with little to lose would be encouraged to not comply with pre-trial discovery rules. The court did not abuse its discretion in precluding the testimony. And this is what the court in Jackson also ruled. Rather than comply with reciprocal discovery rules by giving the people the name of the witness and the proposed testimony, he chose to surprise the people with the statement at trial. Admitting such potentially unreliable evidence, untested by cross-examination, would not only have prejudiced the people's case, but would have undermined the discovery process. So the situation we have is not quite like Jackson, but it approaches Jackson. I believe that under Jackson, I would have had the authority to preclude Mr. Levin from giving any testimony about this recently discovered evidence, or this information that was recently turned over to the police about him taking possession of the prop gun and what he did with it. If I did that, however, the defense case would be prejudiced. But then I'm also concerned about prejudice to the people, because this came late in the game. So this is the way I thought it could be remedied, so that neither side is prejudiced and both sides can fully present their case. Before Mr. Levin takes the stand, I required that he agree to a complete interview by the prosecution, and I understand that happened.
Yes, after initially refusing to speak with us. He spoke to us a few moments ago.
I also required that the person who took possession of the gun, the director in New York, that he be interviewed on tape by the people, and if Mr. Levin testifies to anything that is inconsistent with any prior statements he made to this person in New York, that the tape can be played to impeach Mr. Levin's testimony, if there is any. So that's the way we're going to remedy to ensure both sides are treated fairly, neither side is prejudiced, both sides get to fully present their case. Now, I understand, Mr. Lewin, you interviewed Mr. Levin for a period of time, and you said some additional information has come forward that you did not have on Friday, which relates to the witness on the stand now?
Yeah, yes, Your Honor. Both from, it's going to be important, I don't want to disclose it, but I can tell you that based on what we're being told now, there are going to be questions I'm going to have to ask of the current witness on the stand. With that in mind, I'm asking the court for an additional 30 minutes, and I understand the court is given 90. I'm going to ask for an additional 30 minutes, and I can promise the court I will finish during that time.
All right. Is this information that you did not have on Friday while you were cross-examining the witness?
Yes, that is correct.
So when did you discover this additional information?
Well, I discovered it in speaking to the individual, and just so it's clear, when they turned over the information last night, they still did not identify who the person was. And the court ordered that it be turned over this morning. They didn't immediately turn it over. I found out who the person was sometime around 8:30 this morning, and we were able to call him, and we interviewed that individual.
Did his identity and contact information come from someone on the defense?
Yes, and so eventually they supplied it. I sent a very nasty email explaining to them that I wasn't asking for it, the judge ordered it, and they better turn it over. And they finally turned it over.
All right.
They interviewed him this morning. We then interviewed Mr. Levin, and there are, as a result of those two interviews, there are some issues that I now know.
All right. Okay. All right. I had said Friday, 90 minutes, and that was in stone, 90 minutes. However, because of the new information, we'll get the additional 30 minutes.
We appreciate it.
So it's a total of 2 hours and not 121 minutes, 120 minutes.
Right, although you did say, Ron, you would let my co-counsel have the clock.
Yeah, I don't care who times it, but
You were a little quick on what you're, Your Honor.
so it's going to be 2 hours from the time he takes to stand.
Yes.
I just want to remind everybody at council table, CCP 177 still applies. I'm not going to tolerate any speaking objections, arguing with a witness, arguing with each other, snide comments made to each other, and arguing with a decision of mine. That still remains in full force and effect. All right, let's bring in the jury.
Your Honor, there's one last thing that we need to put on the record. One, regarding the court's last comment, we just want to make sure we have to get into grounds because we cannot respond if we don't get grounds. The court's ordered it, so I would assume
The defense is well aware.
Okay.
If there's an objection, the legal basis has to be stated.
The second issue, Your Honor, the court said the court did not want to, quote, cast aspersions of either side. The court has found that this was not inadvertent.
That's right, and nothing more need be said about it. I did not find it was inadvertent. That's why I came up with the remedy I did. I don't want to talk any more about it than I already have. Let's bring in the jury. Oh, and 12 years. And I've got a clock too.